Hello everyone, welcome back to Tutelage Legal. Today's session will be on the exceptions of the principles of natural justice. After having a brief discussion on the concept of natural justice and its principles, now it's clear that these principles, though not codified but have a binding effect on all courts, judicial and quasi-judicial bodies as well as on administrative authorities also. And if any action of these bodies infringes the rights of an individual, that person concerned may challenge such an action on the ground of the principles of natural justice. However, there exist certain exceptional situations which may exclude the principles of natural justice. Such exceptional situations may arise due to statutory exclusion, due to legislative actions, due to certain emergency situations, in the interest of the general public, due to impracticability, or on the basis of certain constitutional provisions. So let's have a brief discussion on all these principles along with certain important case laws. The requirement of natural justice can be excluded by a statute, but such exclusion must be reasonable one and must not be arbitrary. Such a statute excluding the principles of natural justice must stand within all the conformities of the Constitution. Otherwise, it can be challenged on the ground of the violation of the Constitution, and it shall be subject to the judicial review of the courts. The case of Delhi Transport Corporation versus TTC Mazdoor Congress can be cited here, which came up in the year 1991, decided by the Supreme Court, where AIR page number is 101. In this case, what happened? The Delhi Transport Authority, which was empowered to terminate the service of the permanent employees without assigning any reason and without providing any opportunity to them for hearing, was challenged. And the Supreme Court held that the regulation which empowers the authority in such a way was violative of the principles of natural justice as well as was against the Constitution and violative of Article 14 of the Constitution. Parliament in India is not a supreme authority, and any law made by the Parliament in order to be valid must be within all the conformities of the Constitution. Coming to the second point of exception, that is, principles of natural justice can also be excluded by legislative action. These principles are not applicable to legislatures, as the legislatures do not lay down rules for a single individual. Rather, it lays down the rules for the community at large, for the public at large. There is an interesting case on this point, that is the case of Charan Lal Sahu versus the Union of India, which came up in the year 1990 and decided by the Supreme Court. In this case, what happened? The Bhopal Gas Leak Disaster Act, which passed in the year 1985, was challenged on the ground that it took away the right of the victim to establish their own case and thereby their right for fair hearing. The Supreme Court, rejecting the challenge of the petitioner, held that the statute on reasonable ground, the legislature on reasonable ground, can take away the principles of natural justice and the right of the victims of fair hearing or to give hearing. Coming to the third exception, that is, principles of natural justice can also be excluded on the ground of emergency or due to the extreme necessity. In exceptional circumstances or In the cases of extreme emergency, where prompt and preventive action is required to take, principles of natural justice may be excluded or need not be observed always. But such exclusion shall always be subject to judicial review of the courts. Here, the Emergency Power Act 1934 can be mentioned, as this act empowers the government to make regulation for the detention of the persons on the ground of safety and security of the country. Coming to the fourth point of exception, that is, the principles of natural justice can also be excluded in the interest of general public. For example, traditions like destruction of unwholesome food, destruction of contagious plant or animal life can be taken without giving any opportunity of hearing in the interest of general public. The famous case of Maneka Gandhi versus the Union of India, which came up in the year 1978, decided by the Supreme Court, where AIR page number is 597, can be cited here. In this case, the Supreme Court held that the authority, that means an administrative authority, can impound the passport of the petitioner in the interest of general public. But before doing that, the opportunity of post-judicial hearing should be given. Here, I must mention that post-judicial hearing means the hearing which takes place after provisional decision is reached. These types of hearing can be initiated in the cases of emergency or in exceptional cases. Coming to the fifth point of exception, that is, principles of natural justice may also be excluded in the ground of impracticability. The judicial approach to the rules of natural justice is always pragmatic or practical, where the number of the persons so large that it is not practicable to give all of them opportunity of being heard, the court doesn't insist on the observance of the principles of natural justice and fair hearing. The case of R. Radhakrishna versus Osmania University can be cited here, which came up in the year 1978. In this case, what happened? The entire MBA entrance conducted by Osmania University was cancelled on the ground of mass copying, and the court held that notice and hearing to all the candidates is not practicable in such a situation. Last but not the least, principles of natural justice can also be excluded on the ground of certain constitutional provisions also. The Constitution of India has nowhere used the expression natural justice. Neither it has defined the expression natural justice, but these principles forms the basis, provides foundation of certain constitutional provisions like Article 14, Article 21, 32, 226, 227, 136, 311 of the Constitution. But while discussing about the exception of the principles of natural justice, the second provision of Article 311 Clause 2 must be mentioned. Article 311 provides protection to a person who is an employee of the state government or union government against arbitrary dismissal, removal or reduction in rank. It says that no civil servant shall be dismissed, removed or reduced in rank except after an inquiry in which he has been informed the charges against him and give reasonable opportunity of being heard against those charges. So, Article 311 basically tries to give effect the rule of audi alteram partem or fair hearing. But the second proviso to this Article 311 Clause 2 creates certain exception to the principle of natural justice. It provides that it is not required to give reasonable opportunity of being heard or inquiry to a person, that means to such an employee or civil servant, if three types of situations are there or exist. That is, where such a civil servant is dismissed, removed or reduced in rank on the ground of misconduct, which may lead to criminal charges or conviction, or when it is impracticable to give him such an opportunity according to the authority taking action. But if the authority takes action on this ground of impracticability, it must record the reasons in writing. And when it is in the interest of the security of the state, not expedient, not wise to give him such an opportunity. In the case of Tulsiram Patel versus the Union of India, which came up in the year 1978, decided by the Supreme Court, it was clearly laid by the Supreme Court. It was clearly held by the Supreme Court that these three exceptions, which are provided by the second proviso of Article 311 Clause 2, are mandatory, and no service rule can disregard them. So that was all about the exceptions of the principles of natural justice. If you have any question, any query about today's session, you can comment me to the comment box below. Thank you for watching.